Thank you very much for your introduction. I will start now. Hello, friends. I am Satish Prabhu. We are just discussing Consumer Act 2019. So before starting that, I first want to bring you to the root of the matters. That is, who is consumer? Who can file consumer complaint? Before filing a consumer complaint, the person must be picked in the definition of Consumer Act. I will not take you to the definition as given in the Consumer Act. I want to make this session very friendly and very easy for all of us to understand. Okay, friends, as we all know, first of all, who can file the complaint? The person who purchased some goods from any shopkeeper, wholesaler, retailer, okay, and that goods or that product turned out to be defective, right? And even after giving a lot of opportunity to the dealer and the shopkeeper to rectify the defect, the person is not rectifying the same. In that case, the person, the purchaser of that product is a consumer, and he can definitely file consumer complaint in the consumer forum. Earlier we used to call, now we are calling District Consumer Dispute Redressal Commission in district side, and then state side you all know state commission. Then we have national commission at national level. So friend, the same way, not only the person who is a purchaser of the product, friends, but also any person who is hiring the services from the professional person or any person for consideration. Very important point here, when you're buying the product, for consideration is the important point. If you are taking some product free of cost, or somebody is giving you some product, and that product turned out to be defective, in that case, you can't file, you are not a consumer, nor you can file a consumer complaint. Okay, friends? The same way, if you are hiring the service of a professional person or any person for consideration, then only you can come under the category of consumer. So friends, when you are hiring the service of professional, who is professional? Engineer, doctors, chartered accountant, contractor, friends. So any persons or services you are hiring, and you are paying consideration to that person for his service. And if he not done his work properly, there is a deficiency in his work, lot of shortcomings, defects in his work. In that case, again, you can give an opportunity to rectify the defects. Till if he's not rectify that thing, you can file a consumer complaint against that person, that professional person. Now, all are come under the category of this, right? All professionals except advocates. You know why? We are not only doing service to the people, but not only we are taking fees and doing for the people, working for the people, but we are also doing social work, We are taking the people's grievances to the court and trying to solve the problems. So we are up to certain extent protected by the court when we do take due diligence and do our work properly. We are protected, Yeah. Now we don't have to take advantage of that, and we have to do our duty very professionally, very diligently. Okay, friends? Yeah. Now, so we can file complaint for defective products. We can file complaint for deficiency of service. Okay. The same way, we can file complaint for unfair trade practices adopted by the salesperson, wholesaler, retailer, distributor, etc. Friends. Now the question comes, where to file the complaint and what is the limitation to file the complaint? Friend, first thing, limitation is 2 years. Within 2 years of cause of action arise, you have to file the complaint before the concerned district commission. Now you'll ask me why I said concerned district commission, because we have to see the jurisdiction. Now we have district consumer commission throughout India, right? Not only in Maharashtra. Okay, so consumer courts are there. Generally we call consumer court here, but they are consumer dispute redressal commissions at district level. Okay, and at state level we have state commission, and for full country we have that national commission. Okay, and above that, if you want to challenge any order passed by the national commission, then you can go to Supreme Court. Okay, friends. Now, again comes the limitation. As I said, as the cause of action arises, you have to file the complaint within 2 years of arising cause of action. And after 2 years, you can't file the complaint. But because of some genuine reason, you are not able to file the complaint. In that case, you have to file condonation of delay application along with the complaint. In that case, before admitting your complaint, court will issue notice to other side. Other side here in consumer complaint are called opposite party. Okay. And in district level, they are called samne wala, virodak. Okay. That is. So first court will decide the condonation of delay. You have to explain the delay, why there is a delay, why you have not filed the complaint within stipulated period of 2 years. And after hearing the other side, you have to explain the each day's delay. Definitely. When the limitation is given by the act, we have to be very vigilant and we have to file the complaint within time frame given by the Consumer Act. But suppose there is a delay, then you have to explain the delay, and if the court considers there is a genuine reason, and court may condone the delay and impose some cost. Okay. Okay. Now you understood this. Now next part is where to file the complaint again. Okay. Which district commission you will file? See, earlier, now we are dealing with 2019, but before that we had 1986, right? Consumer Act 1986, also very beautiful piece of Consumer Act. Okay. According to that, consumer complaint can be filed where the opposite party is having its office or doing business and where the cause of action arises. But now, friends, because in 2019, there is a amendment and changes, very beautiful change. This increased the jurisdiction where complaint can be also filed where complaint resides or doing his business. Okay. So suppose cause of action arises in Pune and you are residing in Bombay. So there is no need for you, like earlier, as per 1986, you have to go to Pune and file the complaint, right? But now you have to file complaint. You can file complaint in Bombay or you can choose the jurisdiction. Suppose even though you are staying in Bombay, you want to file in Pune because you are frequently going in Pune. Okay. And opposite party's office is in Pune. Cause of action is in Pune, then you can file in Pune also. Okay, friends. This is the new changes brought by this new Act 2019. Now, friends, another changes brought by 2019 Consumer Act is you can file online complaint. Okay. So no need for you to go to physically to the Consumer Commission, at least at the initial stage. You can file online, but later on after filing, you have to visit the commission and tender the hard copy also to the commission. Okay. Now, friends, now up to what value you can file in which commission, you know. Now, we can say up to 50 lakh, your consideration amount or disputed amount or service charges amount is up to 50 lakh. You have to file consumer complaint in district commission. If you see the Bayer Act, it is written there that district commission have power up to 1 crore. But friends, there is an amendment by the government and there is a notification. So this power is reduced. Once it is increased, then again it was reduced. Now, as per the law, a notification and circular, up to 50 lakhs disputed amount, or you can say consideration amount. What is your consideration amount? That is the most important question while admitting the complaint. Up to 50 lakhs rupees, you have to file the complaint in district commission, consumer commission. Okay, dispute redressal commission. Okay, which is generally called in Maharashtra or in local languages Grahak Manch, Grahak Nyayalay, or Grahak Manch. Okay. Generally, the proceedings of this consumer commission throughout Maharashtra, it is held in Marathi language. Okay. And if you go to MP, I had the chance to go to Bhopal, Indore, and I had opportunity to appear before those commission, where generally all the proceedings are in Hindi. Okay, you can file definitely in English proceedings, but they prefer sometime, generally other side will file the complaint in Hindi. Okay, and you can file it in English, no problem. I done that. I did my pleadings in English only, but while arguing the matter, and I started in Hindi for up to certain, to have a rapport with the court and the judge and the, to get the feeling that I am local there. In Bhopal and all, I started my argument first in Hindi, and then legally I shifted to English. Okay, because law point and all, everything, we are more comfortable arguing in English only, and even Hindi arguing is a little bit difficult. We can put our facts, but argument is preferred by the in English language only. Okay, I'll come back to this. Up to 50 lakhs, I said you have to file in the District Consumer Commission. And then above 50 lakh, up to 2 crores, you have to file the complaint in State Commission. Okay. And above 2 lakhs, 2 crore, your disputed amount or the consideration amount which you are seeking is above 2 crore. Then you have to go to National Commission. Okay, friends. Now, friends, what is the difference? Like somebody, you paid the goods, you supplied the goods, somebody supplied the goods and he's not paying the amount or something like that. You book the tour and tour company is not conducted the tour and you're asking the refund of the amount, etc., etc. So you have remedy to go in the civil court also. Like you purchase a flat and the builder is not giving you the possession of the flat, right? You can go to the civil court. But if you go to the civil court, you have to pay 3 to 4% of court fee on your compensation or whatever claim amount. Now, this is the best advantage why you should go to the consumer courts. You don't have to pay such a huge amount of court fee. Here, court fee is very nominal, very nominal. These consumer commissions courts are created for the common people so that every litigant, very simple person can afford to go to these courts, where the up to 5 lakh, if the claim amount is up to 5 lakh, no fees at all, friends. Okay, then up to your claim amount is up to 50 lakh, then you have to pay only 1,000 rupees. And if your claim amount is up to 1 crore, then 2,000 rupees. Likewise, it's a very nominal amount. Okay, and friends, one more thing, to approach the this consumer court, it is not mandatory that you must engage a lawyer. Any common man can also approach the consumer court. Okay, format of the complaint is given or displayed in the consumer commission. Any layman, ordinary person can go and see that format is given, and accordingly complaint can be drafted. Okay, but thereafter, after filing the complaint, friends, as I told you, within 2 years you have to file the complaint. But before, friends, before filing the complaint, okay, what you have to do, you must give opportunity to other side, opposite party. Calling upon other side, like suppose you purchase a product which turned out to be defective, then you must first complain to the shopkeeper and the wholesaler, okay, and to the company that such and such product, suppose TV or computer, whatever you bought is defective, and let them give chance to repair. And if it's a major defect or what we call manufacturing defect, then you must ask for replacement of that product. Okay, friends. If they are not doing that properly or they are failed in that case, you don't have to wait. What you can do, it is better to give a notice to advocate. Put all the facts before in that notice, inform what the defects in the product, and call upon the other person to rectify the thing or replace the product. Okay, and if it's not doing, give him chance of 14 days. Okay, and then to file the complaint in the court, in the consumer forum, right? Now, friends, earlier as per 1986 Consumer Act, once you file the complaint, there was, second stage is after filing the complaint is admissibility of the complaint, right? Now, there was no time limit given to the consumer forum earlier, so within how many months or how many days they have to decide the admissibility, right? That is, once you file the complaint, then you have to argue and convince the court how the complaint is maintainable, okay? And you have to convince the court prima facie that that's a material to admit the complaint and court is required to issue the notice. So there was no time limitation given. So earlier, sometime, even after filing the complaint, 2 to 3 months or 4 months also, dates are given. Because of maybe court is busy, sometimes advocate is busy, some reasons. Some reason delay used to occur. But now, because of this Consumer Act 2019, friends, now there is a very important amendment in this, which says, this act itself says that once the complaint is filed, the commission or state commission or national commission, wherever it is filed, they have to decide the complaint within 21 days of filing the complaint. Okay. And suppose if now you'll ask me, friends, that if the complaint is not decided within 21 days, then what will happen? What will happen, Law Act says if the complaint is not admitted, because court has to decide the issue of admissibility. If the complaint is not admitted, in that case, there is a presumption or it's a deemed admission. Now court can decide the matter. It crosses the 21 days. That's why there is a binding on the courts, consumer courts, that they have to decide within 21 days whether to admit the complaint or not. If court fails to admit the complaint because of some reason, whatever, law says no. Complaint is deemed to be admitted under section 21 of Consumer Protection Act 2019. This is very important. We can say amendment or rectification where people are benefited, right? We lawyers also, you can concentrate on this work and then finish other works. Okay. Friends, once the complaint is admitted, then what? Once the complaint is admitted, court will issue notice. Commission will issue notice to other side to appear and file the reply. Suppose today court is admitted my complaint and court is given the next date for appearance of after suppose November, okay, after 2-3 months. So whether other side is required to appear on that day and file the reply? No, friends. As per Consumer Protection Act, other party, that is opposite party, are required to file their reply version or written statement to the complaint, to admitting or denying and putting their version within 1 month, which is mandatory. They have to file the reply version within 1 month of receiving the copy of the complaint. And complainant is required to file the complaint and annex all the documents on which he is relying. Okay? Complaint and document evidence, what we call, with the list of documents. Now, once it is received by the opposite party, they are supposed to file the reply or written statement within 1 month. Suppose they are not able to file within 1 month, they can approach the commission and request them because of some reason they are unable to file it. So this time can be extended 15 days more. Okay. So totally, commission can give maximum time 45 days, and within 45 days, OP, opposite party or respondent, samne wala, virodak, they have to file the reply version, okay, within 45 days. Not only reply, but along with all the documents on which they are relying, they have to annex with that reply version. Okay, friends. The other side don't have to wait for the date mentioned in the notice. They have to file the reply within 1 month. Okay, friends, or 45 days maximum. Now on the next date, now suppose date is not there. Okay, so what OP can do, take the matter on today's board and file within 1 month. Okay, you don't have to wait. Once what happened, I'll just share my experience. There was a matter where I am supposed to file the reply within 1 month, okay, for my client. And I'd taken the reply, everything was ready and went to the district court. I will not name that court, okay. So that the judge was absent, okay. But there were 2 courts, other judge was present. So I went and I told the staff to take this matter because I have to file it within 1 month. That Babu or the clerk, he said, no, today magistrate is not there, come day after tomorrow. I said, no, I can't wait. I have to file within 1 month, 30th day. Today is the last day. He said, why you waited? I said, I have right to file up to 30 days, and if required, I can extend 15 days more. I can ask the court. But he was not taking the matter. So I told him, he said, you meet the register. I said, I met the register also. And I told the concerned staff, if you not take my reply today, okay, then if something goes wrong and court passes any order against me, then you will be personally responsible. I will see that you will be personally responsible, and my company will file case against you for this. So he got scared, and he's taken the matter to the in-charge court. I told him to take the matter to the in-charge court, and that in-charge court asked me what is their urgency. I said, as per law, we have to file within 30 days. I don't want to take chance of 15 days. So today is the last day. I want to file today. And he's not taking what I'm saying. You just take it, acknowledge it, so that there will be proof with me that I have filed within stipulated period. Now, friends, then judge said, yes, you have to accept. Why you're not accepting? So court told me to file it, and then I filed it. So this is one example. We advocates have to fight for the client. Sometimes, staff, we are always try to maintain good relation. But when it comes to the interest of our client, we have to be strict also. We have to show that we are advocates, right? For our rights, we have to fight. Anyway, a complaint was put. Anyway, friends, after filing the complaint within the stipulated period, we complainant also have to prove to the court that other side is filed it in time. So we have to file the, what we call register ready slip along with the acknowledgement card and service report. In civil side, we do that, service report, and we'll file of serving the summons, right, to other side. The same way, here we have to file that service report, that is service affidavit, okay, and postal acknowledgement. And register ready, now we have speed post register slip that we have to show, and we have to satisfy the court that they are filed in time, or if they are not filed in time, then we can tell the court they are not filed that WS in time. Then what will happen, friends? On the basis of this documents, we can tell the court they are not filed that WS in time, or they are not yet filed. In that case, we make application to the court that no WS order, right? Like we do it in family court also. We do it in CPC, civil court also. But civil court 30 days, which can be extended up to 90 days. But here there is no provision like that. You have to file that within 45 days. So here, court take it very strictly. If they not file in time, and on your application, that is complainant's application, court have to pass the order of no WS or no reply order. And now the matter will be proceed without WS on record. Okay. Now, friends, after this, after filing the WS, what is next? What is next is complainant is required to file his affidavit of evidence. Okay. And OP, opposite party, is also required to file their affidavit of evidence. Both the parties can file their witness affidavits. On any witness they are depending, they can file. If they are depending on some experts' opinion and all, it can be filed, friends. Okay. And both the parties are supposed to, like opposite party, while filing the reply, they are supposed to file their documents, on whatever documents we call in Marathi dastayevats. Okay. They have to file the list of documents with all the documents on which they are relying. Now, consumer courts are very, very useful in the matters of builders, deficiency committed by the builders. Friends, what happens? A common person book a flat, right? And then builder assure them that I will give you the position within 3 years or 5 years. Okay. And he pays the full amount. He takes loan, home loan and all. And suppose that person is not delivering the flat, then what to do, friends? You can approach the civil court. Then civil court, again, you all know how long it takes, right? Again, when you are going civil court, you have to pay court fee, 3%, 4%, whatever, on the claim amount. That's why, friends, here the consumer courts are very useful to people, or middle class people and the poor people also. They can approach the consumer court, right? As I said, as per the value, if the flat value is above 50 lakhs, it falls within 2 crores, then you have to go to state commission and file the complaint, right? Once the complaint is filed, and the same procedure which I told you. It is required to be served to other side. They have to file their reply. Then both the parties will file their affidavit of evidence. Here we file in court, no, civil court, examination in chief, right? In lieu of evidence of complainant. Same way, here we file affidavit of evidence of complainant, right? In the family court, we write claim affidavit of the parties, right? So here we have to file this affidavit of evidence and all the documents. Okay, friends. Now here, when the builder is not giving the position of the flat in time, or builder given the position, but there is a lot of deficiency. The work is not carried out properly, and the benefits or the facilities which he agreed to give is not given. So many things nowadays. Some builders are doing all this type of things where you are not helpless, friend. You can approach the court for delay of the position also. OC is not obtained. So many things, sometimes some builders sell their project to some other builders. The cheapest way, cost saver, is to approach the consumer commission for such type of things and get relief from the consumer commission. Okay, whether it's a district commission, state commission, or national commission. Okay, friends. Now, after filing the complaint, as I said, after affidavit of evidence, generally, friends, there is cross-examination is generally not held in the commission. Okay, what we call in trial. Okay, so here no cross-examination. Matters generally decided on the basis of the affidavit of evidence and the documentary evidence filed by both the parties. Here also there is no provision as rejoinder. What we file in a civil matter, civil side we file no rejoinder. Once one party files the reply version, other party again file the rejoinder, admitting, denying, this is not correct, this is not like this. So it is not that. What you can do is when you file your affidavit, in that you can take that stand that whatever they stated is not correct and all. This is the correct position. That. And the same way you can file your witness statements, witness affidavits. Okay. And documents concerned, you can file in the court. Okay. It is not that these consumer commissions are not conducting or taking a cross at all. But generally it is not, because these are summary disposal of the matters. Okay. It is not like a regular courts. It's like a tribunal, right? But friends, when in the cases of medical medical negligence and all, there is allegation of the doctor. In such cases, in certain matters, when the cross-examination of the doctors is required, court may allow. Okay, so very few matters, when court feels it is necessary, court may allow the party who wants to cross-examine, make an application to the court. And generally, court sometimes gives a questionnaires, and that questionnaire which complainant asks to the other side, or the doctor, whoever, fill up and give it back. But in some certain cases, court feels that okay, it is necessary to examine doctor or cross-examine. That case, court will allow. Okay, friends. So court will proceed in that case after the cross-examination. Okay. Now, after affidavit of evidence are filed, complaint is filed, complaint is admitted, let us presume. But friends, it may happen that some people, even after issuing the service, they don't appear in the court. काय करतं कोर्ट बघूया, आम्हाला काय त्याची पडली नाही. Some people are like that. They don't appear or they don't give importance to the consumer court. काय होतं consumer court? काय करतील आपलं? Like that. So in such cases, friends, if even after service of the complaint, if the complainant is not coming, first of all, the complainant can, opposite party is not coming, so he can make application for no WS. Okay. Still, suppose opposite party is not coming, he can make application for ex parte order. Okay. And if the court sees that the summons are properly served or notice is properly served, and he deliberately not coming before the court, court will pass the order of ex parte. And once, friends, ex parte order is passed, then later on, commission will not allow his reply version. Court will not allow to file his affidavit of evidence in the court. Okay. And court can only hear him on legal point, argument. That's all. he will lose his chance of tendering his evidence in the court. And court will decide on the basis of the what is evidence there on record. Definitely complainant's evidence, right? So friends, in such cases, court will hear both the arguments of both the party and then decide the matter. Okay. So here, after all the pleadings are over, pleadings means complaint, then reply version, then affidavit of evidence of both the parties, okay, documentary evidence, expert evidence if any, right? And after this, written argument. Generally, commission tells both the parties to file the written argument in short, you know. And then court will hear oral argument. And after hearing the oral argument, court will pass the final order or the judgment. Now, what judgments court can file? Okay. Now, friends, say, suppose it's a matter regarding the goods, defective goods or something like this. And it is proved that goods were defective and he's not rectified that mistake. You know, court can order to refund the amount of that product with interest. Okay. Or court can tell, suppose the complainant insists, you can give the new brand or replacement of the product. Okay. So that product will be replaced or the refund of that value of the goods will be given. And friends, this is very important. And consumer court or commission can impose compensation for physical and mental agony caused to the parties. And that refund, I said, suppose court is imposing a refund. What was the price of that product? Suppose 50,000. Okay, refund the 50,000 amount with 8% or 10% interest per annum. Okay. In addition to this, compensation for causing physical and mental agony, okay, to the purchaser. This can be ordered. Okay. To the builder who is not given the position of the flat, court can order him to give the position of the time and impose heavy interest and heavy compensation. Along with this, court or commission can also impose litigation costs. Okay. So this way, the complainants are, our consumer is benefited. Okay. Yes. Any questions are there? I will take at the end. Now I have still 10-15 minutes, so I will continue. Then I will be taking questions at the last 10-15 minutes. If whatever time. Suppose if I am not able to take all the questions, friends, you can note down my number 9821276210, and later on you can ask me and I will try my brother advocates, whatever help I can. Okay, friends, let us proceed. Now, as I said, once the order is passed by the consumer court or district courts and other party is not happy with the order, what that party can do is they can file appeal. Suppose it's the order passed by the district commission, then district commission order can be challenged in state commission within 45 days. Within 45 days of passing the order, one has to approach the state commission and file the appeal. And if any order is passed by the state commission, then one has to approach the national commission within 30 days of filing the appeal. Okay. Passing the order on appeal. Okay. And any order is passed by the national commission, if any party have grievance, they can approach Supreme Court. Okay. Within 30 days. Friend, beside this, if any party feels during the proceedings that any order is passed, it's a violation of their fundamental rights or some legal rights, they can approach the concerned high courts also. Okay. So you can approach the high court. So these types of orders are passed. Now, friends, this 2000, now I'll come back to Consumer Act 2019, which made a lot of changes in this Consumer Act, friends. And what is that? New provisions are added. This act is created Central Consumer Protection Authority. Okay, what is that? Central Consumer Protection Authority, which is also known as CCPA. Okay, it's a regulatory body created by central government Friends, suppose an individual person rights are violated, that person moves the consumer forum, consumer commission. But if it's some violation of consumer rights, or there's a mass level of unfair trade practice in a big level, which is affecting the class of people, group of people, or general public, or it's a violation, okay, of their rights, in such cases can be referred to the CCPA. CCPA, this is a new thing which was not done earlier, 1986. So friends, so group complaints or consumer matters, rights or unfair trade. And friends, one more interesting thing is advertisement. Any person who gives false advertisement or misrepresenting advertisement can approach. When it is affecting the number of people, class of people, can approach the CCPA. CCPA is an authority created by the central government. Its head office is at the moment located in New Delhi, friends. And procedure there is as what they decide. CCPA decides. Okay. And they will decide the matter very quickly, within 2-3 months. Okay. So any order passed by the CCPA, and then CCPA is having a lot of power, friends. They can have investigation wing. Okay. And not only this, CCPA can so moto also initiate the proceedings. One thing, they can initiate the proceeding when they get complaint or reference or something from the central government or direction from the central government. Secondly, so moto, if something is mass violation of their consumer rights or unfair trade practice or misleading advertisement or false advertisement, such type of things comes to their notice, the so moto also they can initiate the proceedings. They can do the inquiry, or they can investigate. They have their wings, investigation wings, or they can send this matter to the collector or general police, other authorities for investigation, inquiry, etc. And they can call on the report, and or they can so moto also. They can even after receiving the complaint from the public also, they can their own also conduct the inquiry, investigation. And after that, they can pass the necessary orders, friends. And this necessary orders, if not complied, then it is offense. It is an offense. Okay, where court can impose the penalties, fine. Okay, and 6 months imprisonment court can impose. Okay, and as I said, it's a very interesting about the misleading and this advertisement. Now we see this some type of advertisement in the TV and all, or in theater when we go, by putting this oil, hair will grow. और टकलू को भी बाल आ जाएगा. Right? They show, ladies का भी they show, no? By using this shampoo, you'll get a lot of hair, right? Like that. So if there is a misleading ad, we have seen that these authorities have taken action against Baba Ramdev, his products. Also, it must be read in newspaper and all. So some companies when do such type of misleading ads and all, what the CCPA can do, they can prevent them from putting such type of ads. Even the actors or actress who are are there in this ad, giving advertisement, or models in this ad. Action can be taken against them also. Clarification can be asked from them also. Compensation can be asked against them also. Okay, friends. So, friends, this, as I said, if after receiving such complaints about the false advertisement and all, if what CCPA can tell them to stop such type of ad, and after inquiry and all, if they are responsible, they can ban them for a year or maximum for 3 years. For giving such ad, even to the models can be banned. Okay, and if they found these people guilty, and then even punitive action can be taken against them. They can be sent behind the bar for this. Okay, so this type of action can be taken against them. Now, friends, I will, because the time is less and we have to cover a lot of topic, I will go a little fast now. Now, once any order is passed by the district commission, okay, or state commission or national commission, and other side is required to comply that order within stipulated period. other party is not complied that order, then what? Right? Suppose civil court passes some order in your favor, and that party is not complying that order. Then what you'll do? You will file execution proceeding, right? The same way here also in Consumer Act, under Section 71 of Consumer Act, you can approach the same court. Same court means the court which is passed the order. It is a district court, maybe state commission or the national commission. And you can file under Section 71 before that court for execution of that order. Here, when how the proceeding will be like civil courts, when any decree is passed and you want to go for execution of decree, you approach the civil court, no? The same way, a little bit same way. Here you have to file the execution proceeding before that court, trial court, what we call. And after that proceeding is filed, other side will be given chance to put their say, and then generally court will pass the order for attachment of the property. Wow, correct? These proceedings are. Then under Section 72 of Consumer Act, what you can do is, if you want to take criminal action against them, okay, then under Section 72, you can file criminal complaint before the same court, same commission, because this is you can approach civil under Section 71 for execution proceeding, where the court can order for seizure or seizure of that property, okay, to recover the value. Or if you want punish them, then you can file a criminal proceeding where under 72, where non-complying the order, court will adopt the procedure of summary trial procedure. Means summons tribal procedure, what we do in the check bonds and other matters, notice will be issued, the other side will be called, recording plea, okay. After recording plea, matter will be kept for evidence, and after putting the matter for evidence, generally they record affidavit of evidence, and then cross-examination. And then once the commission come to the conclusion that the party committed that crime, okay, that not obeying the order, okay, then court can impose punishment not less than 1 month up to 3 years. Okay, friends. And not only this, fine 25,000 rupees minimum, which can be extended up to 1 lakh rupees or both. Okay, friends. One more interesting thing here is, sometimes what happens in civil court, other person, suppose against whom you won the case, and he become bankrupt. He's having no money to pay your amount. Then what you do? Nothing. If he's having some property, you can execute that, no. But if he's not having any property, then you can do nothing in civil side. But here, you can go under 71 plus 72. You can file execution for seizure of his property. Okay. Attachment of his property. Same time, you can go under 72 for punishment. So this consumer courts are having, lot of we can go strength to harass the other person. So number of builders are put behind the bar for 3 years for cheating the people, non-complying the order and all. When there is property in their name, definitely it was attached, but nothing was there, then go behind the bar, remain inside. A maximum punishment has given in this way. Now, friends, the question comes, some of you may be interested in knowing whether there are certain important Supreme Court judgments on this Consumer Protection Act. There are a number of judgments passed by the National Commission and Supreme Court. But in nutshell, I will note it down some of the judgments which I will share with you. Like one of the judgment which is passed by the Supreme Court in June 26. Okay. Supreme Court ruled that a home buyer can seek compensation for a delay in the flat delivery even after taking the possession of the flat. Now, friends, what happens? Sometimes, builders are not giving possession in time. Once it is ready also, sometimes the full work is not done. But people are in hurry. Sometimes when we know that OC is not given, still we feel that, चलो पहला पोजीशन तो ले लेते, बाद में देखते. पहला घर में तो घुसते, घर का पोजीशन तो ले लेते. But friends, this is a little bit risky. But चलो ठीक है. Some people take the position, huh? And then after taking the position, whether you can go for delay, because suppose there is a delay of 1 year, in agreement is written that he will give up to 25 December 25. Now he's giving position 26 December. So there is a delay of 1 year. So what we can do? You can file for deficiency of service in respect to consumer commission. Okay. Now sometimes builders take stand that now your right will waived simply by accepting the handover. You accepted the position. Now delayed position, you can file. No. You can file the complaint. Supreme Court recently held in June 26 that no. You have to, builders, they have to compensate them. Just because he's taken the position, he's in a weaker side. He has no shelter to stay. He is having fear that whether he will get it or not. So he take the position. But his right of that delayed cannot be, taken away just because he's accepted the position. Now, friend, there is one more ruling which is passed by Supreme Court in February 26. Measures Kabra Associate and Rekha Rajkumar. Supreme Court ruled that when two concurrent remedies are available, like RERA and the Consumer Protection Act, a complainant must choose. Okay, complainant must elect one, and they cannot later on invoke the Consumer Protection Act. Suppose, friends, as I said, position is not given, etc., etc. The builder is committed to some deficiency. Now you have the opportunity to go to RERA court, right? Or you can go to consumer court. Sometimes it happens that RERA Act courts are a little bit faster. Okay. Earlier they used to give the judgment within 6 months, but nowadays they are also taking 2 years, maybe because of heavy rush there. Anyhow, suppose the person has to decide now because he has remedy, he either to approach the RERA court or the consumer forum. Suppose he choose and decided to go to the RERA court. In that case, later on, after filing there or whatever, he can't approach the consumer court. When two equal remedies are available, right, and you're choosing one, then you can't opt for other remedy later on. Okay, friends, this is what Supreme Court held in the matter of Measures Kabra and Associate versus Rekha Rajkumar Hum, friends. Okay. Now, friends, sometimes it happens that builder, in order to restrain the consumers, or the flat purchasers, they write that in case of any dispute, arbitration clause will apply and the parties will go to arbitrator. When the agreement, such a lengthy agreement, people hardly read it. Somewhere it is written that in case of any dispute, arbitration clause will apply. Okay. Now, friends, whether it is binding. Now, tomorrow what will happen that arbitrators and all, appointing arbitrators is very costly and people will get it very difficult to, pay that amount, arbitration amount, etc. So they prefer consumer forum, which is giving them proper opportunity to put their case, So this question come before the Supreme Court, right? In June 26, the Supreme Court passed the order which held presence of arbitration clause in a builder buyer agreement does not oust the jurisdiction of consumer fora. Consumers' remedies are statutory, independent, and in addition to the other legal remedies available. Okay. So builders can't restrain the consumers that they must, or the flat buyers, that they must approach the arbitrator. Even if such clause is put up, Supreme Court held that no. If the consumer want to go to the consumer court, he can definitely approach, and this arbitration clause in the agreement cannot, take away his rights of approaching the consumer courts. Now, friends, another case is that very interesting. We go to bank, sometime, a deposit or check, and sometimes banks are losing or check, or they don't credit the amount, something like that. So what is the remedy for the common people available? So, friend, there is a very interesting judgment passed by the Supreme Court, which is decided in April 2026. Bank negligence and liability. It's a very interesting case about Canara Bank versus Kavita Chaudhary. Okay. In this case, Honorable Supreme Court held that banks are liable under the Consumer Protection Act for failure to present the check within the prescribed validity period. Now, friend, as you all know that within 3 months is the check's validity, and if the checks are not put up in 3 months, then what will happen? It is the fault of the bank only, you know. Somehow it was misplaced, we are not able to get it, he kept there. This type of reasons will not do. And because of this, when the party is suffering, then one has to, bank is liable. This is what Supreme Court said. Friends, one more interesting case of my client I will share here. My clients here, there are two families, they wanted to go abroad. Okay. So they booked the air tickets. They wanted to go to Kenya. Okay. So they booked the air ticket here. I will not name that which air company. Okay. They booked the air tickets here. They two families, they went to Kenya. After going there, they spent 1 week there with their families. And after a week, when they coming back in Kenya, when they went to the airport, okay, they had valid ticket. Okay. When they gone to the counter, the person told, that airways person said, not issued boarding pass to my client. What they said, boarding pass are already over. Suppose there is a seat of 100, they issued boarding passes. They already sold it. You followed? Last moment, those come, they sell it for higher price. No. Even though my clients would book these tickets 3 months early, you know, when they went to that counter, they were told boarding passes are already issued. So you have no boarding pass. And then they told him that you have to wait, and the next flight is next day. You can go in that flight. So my client called me. I said, you go and make complaint to the manager there, okay, who is the concerned person, authority there, and get something from writing from them, okay, and then so that we can use it in the court here in Bombay. So we went to the and made some little bit drama over there, and he said, what is this happening and all, you know, my family is suffering, and why you people did like this, give me in writing. And they returned there. They thought what this person will do, you know. So he returned there. They returned that over ticket overlapping and something happened because of that, you know, we are not able to send you. We'll put you in a restaurant and all. So I arranged for him, my two clients, their family, and next day flight, they given it. So we filed here in District Commission complaint for deficiency of service, okay, and airlines, very big advocates and all, they came to court to defend them. But they admitted that overlapping and something like this, you know, inadvertently it happens or something like this. They're not able to explain that cause exactly, you know. So this case was well fought, and finally Consumer Court, Consumer Commission, District Consumer Commission given a verdict in my favor, that is my client's favor, and ordered the District Commission to pay 5 lakh rupees compensation. 2 persons were there, no, to each 5 lakh rupees and 5 lakh rupees. So this way, friends, if we fight properly, we can get this thing. Sometimes it happens, and we also travel in here. Flights are delayed. They say otherwise take your money. Okay, we are helpless. Coming flight is delayed, so going flight is delayed, something like that. But we don't pursue the matter. We have to pursue the matter. You must have seen, no? Sometimes we go to some big shopping this thing, mall like DMart or something, and they don't give us bag and all, you know. Earlier they used to give bag with their DMart or name, putting the name. I'm just giving example of DMart. But if they're charging and giving the bag with their product name, DMart name, then if you go to the consumer court, it is deficiency of service, because we are doing free advertisement for them, no? Correct? In that way it is.